All right, good morning. This is the Chapter 3 video lecture for the Constitutional Issues class. And so Chapter 3 is all about the United States Supreme Court. It is dealing with how the Supreme Court, how and why the Supreme Court gets to be this final arbiter on these constitutional issues. One reason is in the body of the Constitution. There is the supremacy clause. It says the laws of the Constitution is the supreme law of the land. This is important because it prevents states in the federal government kind of from usurping away this constitutional authority. Now, as an institution, the Supreme Court is generally fairly popular. It is usually significantly more popular than Congress or the president. People kind of see some stability there. I think they see the justices aren't frequently out in the news making controversial comments or statements. So they're just seen as this kind of stability. They're generally pretty popular. And usually more popular than Congress or the presidency. So the Supreme Court's power kind of rests with this idea of judicial review. Judicial review is defined in your textbook on page 63, and it is this idea that courts have the power to analyze the decisions of other governmental entities. So this is legislatures and the president and the governors of states, as well as lower court decisions. So this is the ability for these court cases to continue to process up. Your your book on page 62 has a chart kind of explaining the path of cases to the Supreme Court. The power of judicial review was honed and defined in a case called Marbury versus Madison in 1803. That case is just this most seminal case for the Supreme Court's power and authority. The Supreme Court's power and authority. This case, I believe we talked about this case a little bit already, but in this case, Marbury was suing for a federal appointment as a justice of the peace. The new government was in with President Thomas Jefferson. His Secretary of State was James Madison. They were refusing to give him this appointment because his political ideology was different than theirs. And this was a good job. He wanted it. He sued for it. And the Supreme Court said that under Congress, there was that once it was sealed, it was official. And so under this congressional law, Marbury should get the job. And so we have the Supreme Court coming in and saying, well, not so fast. That congressional law interferes with the authority of the executive branch, which has clear constitutional authority to kind of fill certain vacancies. This position wasn't finalized until we have a new executive. We're not going to force this new executive to fill their government with people they don't want or people they don't agree with. And so we see, and the Supreme Court says, when it comes to what's constitutional or not, we have this power of judicial review. We are the final decision maker of what's constitutional or not. So Marbury versus Madison is the most important case in constitutional law. It's just extremely, extremely important. And then in 1816, so Marbury versus Madison is 1803. In 1816, we have a case called Martin versus Hunter's Lessee. And in this case, we have a treaty, and we have somebody suing for property ownership in a state, so we have this kind of all these levels going on. We have a treaty, we have the federal government, we have a state government, and the Supreme Court comes in and oversearches their ability to say what the Constitution means on a state level as well. And for our purposes, this is really important. As future criminal justice professionals, this is why what the Supreme Court says matters. This is why when the Supreme Court says the Constitution requires Miranda warnings for custodial interrogation, law enforcement across the country has to comply. So that power and authority stems all the way back to 1816. Now, the Supreme Court has control over their docket, and so I am on the Supreme Court's website, supremecourt.gov, And when you go in, there's a tab about their opinions, how to file, the oral arguments. You can kind of list it, and there's case documents. When you go in here, you can do a docket search. You can search for all this information about who and what is on the Supreme Court's docket. And so how do things get here? How do things get here? That is called the power of certiorari. Supreme Court grants writs of certiorari to cases they want to hear. There are a handful of cases that they must hear. They're obligated under the Constitution to hear, like a lawsuit between the state of Indiana and the state of Illinois. That happens. Indiana sues Illinois in their state capacities. The Supreme Court hears that. But that doesn't happen that frequently anymore. A long time ago, it was much more common. That doesn't happen that frequently anymore. So they get to decide which cases they hear, which they don't. They do this by the rule of 4. So if you want to petition that Supreme Court, you file your pleadings. Supreme Court receives all the pleadings, and then they go through them, and if 4 justices want to hear a case, if 4 people vote for it, we have 9 justices, 9, not 10. So if we have 4 justices vote for it, the Supreme Court, they take that case in. So that's the rule of 4. Now, the Supreme Court, gets about 7,000 petitions a year. They take about 1% or less than 1%. They usually hear between 80 and 100 cases a year out of, a few thousand petitions. So, and that's pretty much that's generally their capacity. So they are taking things at capacity frequently. And just because they say no to an issue once does not mean that they're never going to hear that case again. They frequently will wait for there to be issues at more of the national level, significant disagreements among states or circuits, and then they'll take the case to kind of resolve it. So they frequently wait, but that doesn't mean they're not going to hear it. So on the Supreme Court too, on the website too, you can go to this about the court. The first thing that you get to see is a picture of the current Supreme Court. This is Justice Breyer, this is Justice Thomas, Chief Justice Roberts, Ruth Bader Ginsburg, Justice Samuel Alito. Up here we have Justice Gorsuch, Justice Sotomayor, Justice Kagan, and Justice Kavanaugh. So this is the current Supreme Court. If you go to this kind of current members, you can get some of their biographical information. And then this information here are about former Supreme Court justices who have retired but are still living. So we have 3 that have retired, but are alive but retired. Okay, so but these are the current justices up here. So this is kind of who they are. Your book has a couple charts dealing with the Supreme Court. They are not accurate. They are missing Justice Gorsuch and Justice Kavanaugh, both of our newer Supreme Court justices. They explain the political party that each person belonged to before they joined, and then with Justice Gorsuch and Justice Kavanaugh, both Republicans. But then they give you this view, this conservative versus liberal. That is not really accurate based on the more contemporary current court. We see Chief Justice Roberts being very moderate. Justice Breyer and Justice Ginsburg tend to be on the more liberal side, as along with Justice Kagan and Justice Sotomayor. Justice Thomas is probably the most conservative justice on the current court, but it might be up for debate with these 2 newer justices. We just don't have enough information about them and how they're ruling on issues. But if you're curious about the Supreme Court, this is this is the official source, so it's a great source of information about who they are and what they're doing. Now, the rest of your book kind of details out about kind of finding opinions and what an opinion means. So I just want to talk pretty briefly just about this. So an opinion is the written explanation for the decision that they're making. And there are two predominant ways to interpret the Constitution. There's this idea of this living Constitution, but there's also this idea of strict constructionism. And this is the idea that we should interpret the Constitution to mean as close as possible to what it meant the day the founders ratified the Constitution, or the day they ratified the Bill of Rights, or the day they ratified the 14th Amendment, which is coming after the Civil War. So there are these two contemporary debates. Most of the justices use both tools. No justice that I'm aware of on the current Supreme Court is exclusively relying on one tool 100% of the time. When you're actually reading through, they are kind of picking from both sides. And then the last thing, again, if you do want to kind of look through what the Supreme Court is doing, you can go to their docket search, and you can just search for something like, the death penalty. Or you can search for a name if you know exactly what you're looking for, if you've read a newspaper article and you're like, oh, I want to find more information. So you can kind of see, these are all different death penalty cases that are coming up. This one is in Arizona, this is in Texas. And if you click on one, it will tell you this is Travis Reynolds against the Texas Department of Criminal Justice. And you can read, if you click on these, you can read the opinions and pleadings and things like that. You can read the motions and you can see what happened. And then down here on June 24, 2019, it says petition denied. That means the Supreme Court is not going to take this case. They have decided that 4 of those justices did not decide to grant certiorari. So this is just kind of how the docket search works. If you have any questions, you're struggling to navigate the system, feel free to reach out. Also, don't forget to read Just Mercy, your chapters, to make sure you're keeping up with that. I look forward to seeing your discussion board posts later this week. Have a great week.